Good day and welcome. I'm Sizwe Snail Kamtuze. The risk of the use of social media for attorneys and their clients has become a serious legal issue in light of the right to privacy and the right of freedom to expression as enshrined in our Constitution. Our courts have not been oblivious to technological developments and have started accepting that the internet and social media can be used as a suitable medium to serve court papers where suitable. For that instance, you can see the case of CMC Woodworking Machinery versus Peter Ordendal Kitchens. Employees' dismissals can also be confirmed by the CCMA based on social media misconduct. The courts may grant interdicts against persons ordering them to remove offensive or defamatory content from public social media pages, and also the extension of the claim for damages as a result from defamation on a social media platform has now been recognized in law and confirmed by our courts. The right to privacy and dignity in terms of the Constitution is enshrined in Section 14 of the Bill of Rights that provides that everyone has the right to privacy, which includes the right not to have A, their person or their home searched, B, their property searched, C, their possessions searched, or D, the privacy of their communications infringed. In addition, Section 10 of the Bill of Rights provides that everyone has the inherent right to dignity and the right to have their dignity respected and protected. In addition, Section 86 of the Electronic Communications Act 25 of 2002, as well as several parts of the Regulation of Interception of Communication and Provision of Communications-Related Information Act, also known as RICA, have outlawed unlawful interception and monitoring, save where there is written consent or where there are legally justifiable grounds, as stipulated in the RICA Act, or you are a party to the communication thereof. In other words, with reference to social media accounts, everyone has the right not to have his private social media account to be hacked, and personal information thereon being disseminated, or particular views expressed to the public without their prior consent. This should be seen in light of Section 16(1) of the Bill of Rights that provides that everyone has the right to freedom of expression, which includes A, freedom of the press and other media, B, freedom to receive or impart information or ideas, C, freedom of artistic creativity, and D, academic freedom and freedom of scientific research. The exposure of one's views on a particular issue may be legally their right on their private social media page, but if such information were to be leaked, the right to freedom of expression must be balanced with the right of the other party not to be disparaged or to be defamed. In addition, one may ask the question, do you still have a legitimate expectation to the right to privacy, as stated in the case of Bernstein versus Bester, by merely setting your social media settings to a select few? One may, however, argue that if one of your friends makes a screen dump of your Facebook account pages, he or she may necessarily be infringing on your privacy as you had not allowed them access. The question then is, what may you legally do with such access, which may result in you being sued for damages or being subjected to disciplinary action? I will now illustrate how our courts and other dispute resolution fora approach the use of social media at the workplace and in the employee's private space. In Fredericks versus Joe Barkett Fashions and Sedek and another versus Chris Ray, the employees in these two matters were dismissed as a result of derogatory Facebook status updates. They challenged the fairness of the dismissals at the CCMA. In both instances, the CCMA found that the employees were fairly dismissed, as their privacy had not been infringed when their employers accessed their public Facebook posts. The employees had not restricted their Facebook privacy settings, and the updates could be viewed by anyone, even those with whom they were not friends on the website. The CCMA took the view that the employers were entitled to intercept the posts in terms of the Regulation of Interception of Communication and Provision of Communications Related Act of 2002, Act 70, which we call RICA. The Commission decided that the employer was entitled to access the wall posts as the employees had an open Facebook profile. In the matter of Workers' Association of South Africa, on behalf of Mvemve versus Kathoro's Community Radio, the employee of a radio station criticized the organization's board and claimed that the station manager was a criminal. The CCMA found that the employee was fairly dismissed as he has posted unfounded allegations on Facebook without having addressed these internally first. In another matter of Smith versus Partners in Sexual Health, an organization's chief executive officer accessed an employee's private Gmail account while she was on leave. As a result of the unlawful access, he found emails between her and former employees as well as persons outside the organizations which made reference to internal affairs. The employer initially gained access to an employee's account accidentally, but the subsequent access was then intentional. As a result, the employee was charged with a number of offenses, including bringing the employer's name into disrepute and misconduct. In her defense at the disciplinary inquiry, the employee contended that the emails were accessed in violation of a right to privacy and in contravention of the RICA Act. The CCMA found that the intentional access on the second occasion contravened the RICA Act, and that the evidence that had been obtained through this access was inadmissible on the basis of an infringement of the constitutional right to privacy. The CCMA also held that the employee's dismissal was procedurally and substantively unfair. It could also be argued further that the employer contravened the ECT Act, in that Section 86 clearly states that if you are not authorized to have access to an information and accidentally do so, and remain thereon knowing that it is now unlawful, the access becomes unlawful from the time that the employer knew it did not have the right to access the employee's email and decided to remain thereon and access the employee's mail nevertheless. The issue of how the law of defamation relates to social media was settled by the courts in the matter of H versus W. This is where the court held that the court may grant an interdict and order a party to remove defamatory postings on one's social media account that is in the open public. In other words, what you say on Facebook about others must be fair comment or the truth and not defamatory or scandalous if you are using an open profile. In the matter of Esparta versus Richter, the court held that defamation on social media may expose the person making the defamatory statement to a claim for damages by the party having been defamed. The court held that, crude as damages for defamation may be, our courts have consistently awarded damages to the victims of defamation, albeit in the modest amounts. Since the defendants did not apologize or retract the defamatory statements, I believe that an amount of 40,000 in the appropriate circumstances is appropriate. In addition, the defendants were also ordered to pay the plaintiff's costs on the appropriate magistrate's court scale, including the cost of counsel. In conclusion, it is important to mention that due to the increasing popularity of the social media medium, it is important that the attorneys and their clients take cognizance of it and use it in a lawful and acceptable manner. In addition, the LSSA has come up with a social media guideline for attorneys, which is available on the LSSA website to guide attorneys in their practice on acceptable social media practices. I thank you for your time and safe cybersurfing. Goodbye. In conclusion, it is important to mention that due to the increasing popularity of the social media medium, It is important that the attorneys and their clients take cognizance of it and use it in a lawful and acceptable manner. In addition, the LSSA has come up with a social media guideline for attorneys, which is available on the LSSA website to guide attorneys in their practice on acceptable social media practices. I thank you for your time and safe cyber surfing. Goodbye.